Hi, I'm Jeff Cooper, and I'm an attorney, and I'm just wrapping up for the day here. And I have a couple of questions that I've been getting emails about. And so I thought before I left the office today, I would go ahead and answer a couple of those questions for you, since they are questions that come up pretty frequently. So, the first question is about probate, and I'm an attorney that has been helping clients to avoid losing their estate in the probate system since about 2010, and that's what this question is about. And so if you're looking for someone to advise you on how to protect your home or how to protect your estate from the probate system, then this video is for you. So at any rate, it's not surprising that this is one of the more common questions that I get, because in North Carolina, the probate system can be quite a problem for folks and their families after they pass away. And that's because the average probate in North Carolina, it takes longer than a year to settle. So imagine you pass away and your family is still dealing with wrapping up your bank accounts and your vehicles and things like that for more than a year later, right? The second problem is that in North Carolina, court costs can be up to $6,000 per death. And then the third big issue that people have is that North Carolina allows attorneys like myself to charge up to 5% of your probate estate, or technically something called receipts and disbursements, but we'll just use probate estate as shorthand there. 5% of that in executors and attorneys fees, and so it can be a really expensive proposition. For instance, if you have, say, a $300,000 probate estate, then 5% of that is about $15,000, and then court costs in that situation are probably going to be about another $1,500. And so you're going to be $16,500 out of pocket for an estate that size. And many of my clients are like, "Hey Jeff, I don't want my family to lose $16,500 out of my $300,000 when I pass away. What can I do to prevent that?" And so, if you have heard, you got a friend, family member, and you saw their estate go through this, takes longer than a year to settle, spent a lot of money, then I'm going to talk about several different ways that you can avoid that here in this video. So first way to avoid it is joint ownership. Second way to avoid it is beneficiary designations. And third way to avoid it is using trust. So let's go through those three options. But before I go through those three options, I want to tell you what got me interested in helping clients to avoid this whole North Carolina probate situation in the first place. And that is because I was in law school when my grandfather, age 63, was diagnosed with late-stage colon cancer, and he ended up passing away in my second year of law school. And my dad was appointed as executor of his estate. And so my second and third year of law school, I got to have a front row seat of watching my dad administer my grandfather's probate. It took longer than a year, and all of my grandfather's assets went to creditors, the court system, and the attorneys. Literally not a dime went to anyone in my family. And so that whole experience drove me to take as many classes as I could on how to avoid probate for clients and learn more about what could have been done. And since I graduated, I've devoted my practice to helping clients do this very same thing, is protect themselves and protect their family. So on to the three ways that you can protect your family. So first method was joint ownership, right? And so joint ownership is when you and someone else jointly own your property. And so if you're husband and wife, maybe you have husband and wife joint ownership. That's one way to avoid probate. Maybe it's not your spouse, it's somebody else, and you jointly own your property with them. As long as it says joint tenants with rights of survivorship, abbreviated JTWROS, joint tenants with right of survivorship, as long as that is the method of your joint ownership, then you don't have anything to worry about, because when one of you passes away, the other gets to keep everything without having to go through the court probate system. And so that's the first way to avoid probate. Now, before I move on to the second way, one question I get a lot is, should I then take my home or any other asset that I have, and should I add my kids' name on that property? The answer to that is probably not, but I have a whole nother video for that. So you can check out that other video on my Facebook page as well to answer the question, should you add your kids to your property, okay? And I'll explain all the reasons there. But that's the first way to avoid probate is joint ownership, and typically that's with spouses, right? And so that's method number one. Method number two is beneficiary designations. And so beneficiary designations are on assets like life insurance or IRAs or 401ks, or even bank accounts or investment accounts that allow you to put a TOD or a POD on that account. TOD stands for transfer on death. POD stands for payable on death. Those would be provisions that act just like a beneficiary designation. And when you pass away, you may not know this, but those assets go using your beneficiary designation, and they don't go through your will. So if you have a last will and testament that says, I want to leave everything equally to my 3 kids, and your beneficiary designation or joint ownership document says, well, I'm leaving it to my brother, well, it's going to your brother. It's not going through your will, okay? So it's avoiding probate. And I guess I should have made that point a little bit earlier on, which is that your last will and testament does not avoid probate for you. In fact, last will and testament kind of means that everything you do have is going through probate. So first way to avoid probate is joint ownership. Second way to avoid probate is beneficiary designations. And the third and final way to avoid probate is using something called a trust. Now, a trust is a legal document very similar to a last will and testament, with one very big difference, and that big difference is that trusts do not have to go to court to be administered. So you can have your same thing. Maybe you got 3 kids, you want your assets to go to those 3 children, and if that's the case, then you put those provisions in your trust, and all of those assets are going to end up going to those 3 kids without having to go to court, without having to spend a year in the North Carolina probate system, without having 5% statutory attorney's fees, and without having up to $6,000 per death court cost, okay? So those are the 3 ways that you can avoid probate on your assets. 1 is joint ownership, 2, beneficiary designations, 3 is trust, okay? So let's see, what else do I have here? When a client decides to work with my firm to prepare their estate plan, normally their estate plan is going to use a combination of all 3 of those methods of avoiding probate. So some of their assets might be jointly held, some of their assets we might use beneficiary designations, and some of those assets we might place in a trust to avoid probate. And so one kind of quick pro tip that you might want to take away from this is take out a sheet of paper, just a blank sheet of paper, and draw 3 lines on it. You're making 4 columns, okay? So you want to make 4 columns. In above column 1, write my name, okay? So that's any asset that is in your name exclusively. So my name's Jeff Cooper. I'd write, assets owned by Jeff Cooper, okay? Column number 2 is assets you own jointly with somebody else. So I'm married. My wife's name is Natalie. And so in column number 2, I might write assets jointly owned by me and anyone else, right? So my wife, Natalie, or I actually own a company that is co-owned by me and my brother. So that could be also in joint ownership, right? And then in the 3rd column, you want to have beneficiary designated assets. So that's going to be your life insurance, your IRAs, and any bank accounts or investment accounts where you have a beneficiary designation. 4th and final column would be assets that you have a trust in place for, right? And so if you have that legal document, the trust, any assets that are listed in your trust would go there, all right? So now that you have your 4 columns and you've listed out all of your assets, right? So you should be able to do that mostly off the top of your head. I've got 3 bank accounts, I've got 2 savings accounts, I've got, my accounts with my wife, my vehicles, I've got my business that I own, my law business, my real estate, and you can lay all that out in those 4 columns, okay? Anything in column 1 is a potential problem for your family if you were to pass away, and needs to be dealt with either by moving it into column 2, 3, or 4, right? Okay, and so that's kind of a tip on how you can kind of assess what your risk is for probate right now, and make sure that you've got a jump start on before you sit down to meet with an attorney like myself to get your affairs in order. So if what I talked about today sounds like you, and sounds like something that you need to address, then very well. We've got a link here where you can click a button there to schedule a phone call with me if you'd like to talk to me about avoiding probate for your estate. Or we've also got a text message number down there where you text that, and that text comes straight to my office, and either me or one of my paralegals will be able to get back to you in about 24 hours. So 2 ways to get a hold of me. Hopefully today's information was helpful, and I'll look forward to talking with you either via consultation or via text message. So take care.